So then I do a screenshot of it, and I email it to myself to save it. But I found, to my distress, that some of them are pretty long, and they show up in my email, like this, like a little ribbon down the center of the page. Some of them are even smaller than this. Well, then I go to open them up. And it's just a blur. You were talking the other day, one of you two, about it's just like a cell phone where you can expand a picture and make it bigger. Well, it's not making it any bigger. It's making it bigger, but it's nothing but a blur. That was my concern that I wanted to ask Mr. Armstrong about, and I guess I should have, for him to explain it better for me as to how that can be reliable. Because it isn't reliable for me in getting my messages on my phone. Now, maybe if I reset it to a site, I could explode it again or decrease its size again, and I don't know. But here you've got a picture, which I have to tell you, I think it's very blurry.
I agree. And the picture is one of 5 or 6 pieces of evidence. So I know the defense wants to focus on this picture, but the picture is only one. We have 3 videos, one unedited, completely untouched drone video, which I think is where you see it clearest. And then we have one that is zoomed in, and we have one that is slowed down. I believe the clearest shot is actually the original drone video. So we can present that evidence, and they can rebut it. I think you're taking the picture wrong on your phone. I'm not tech support.
Pardon me?
I think you're taking the picture wrong on your phone.
Is that it?
I think so.
I'm not surprised.
But these things are in evidence. You watched it on the screen yesterday, whether you formed your own opinion or not, and that was
my opinion is not what counts, except to the extent that if there's no
Hey, Chris.
if
What's up,
totally,
guys? Dirt McGirt.
If it's just totally unclear, then I certainly can't give a provocation instruction based upon a picture that I can't make anything out of. I agree with you, the ultimate determination of what it shows is for the jury.
It is not based on
You have to be over the threshold.
It's absolutely not based on the picture. It is based on the drone video and the testimony. And this was testimony elicited, if not by the defense, then in response to their questioning. Detective Antaramian testified he reviewed it and saw it, and that was a common question to many people in this case. The photo is like the 5th or 6th most important piece of evidence. The most important piece of evidence on this point is the drone video itself. And that is unedited. There are some edited copies as well that are helpful. But to focus on this photograph, that was almost an afterthought simply because we didn't get it till the day before, and we figured it may be helpful at some point. The photograph is, we may not even show that to the jury. It is based on the drone video and the testimony of Detective Antaramian. It is in the record. We have evidence of provocation. I can't fathom why, if there is evidence in there of provocation, which we have clearly done, why we cannot argue it and why we cannot get that instruction. The defense is free to completely call it whatever they want and to attack it. But that is why we have trials.
I haven't seen it clearly.
What's up, Rose?
I have.
Oh,
Your Honor, they're arguing for something saying we've been on notice from the beginning. And if they wanted to put on the evidence to prove up provocation, all they had to do was call Mr. Zeminski
Let's go, Brandon.
or Mrs. Zeminski to
Gun-built
rebut
kid.
the story that we have. They didn't put them on because Detective Antaramian, Detective Howard both know he's a liar. And they're building their whole prosecution on that without putting them on.
well, they don't have to call a particular witness.
But they don't have the provocation. And, we had all these little things going on yesterday, and I went back to my office, and the whole essence of the problem came down to these 2 facts in the testimony. Examiner Armstrong took 20 hours to manipulate that photograph to get that blurry mess up on the screen. We had our expert do it right in front of the jury in seconds, and it showed what it was. And that's where the hocus pocus and adding the pixels and all the other garbage comes in, and that's what they're building their prosecution on.
Again, we're focusing on a picture that is the. Again, we're focusing on a picture that I've said repeatedly now is the least. The least.
Well, show me the best
convincing.
one.
What?
Show me the best one.
That was the best one.
Yesterday, before Mr. Armstrong was allowed to testify in rebuttal, we went over this about whether or not the methods he was using were appropriate, and we showed you, you walked up to the 4K
Yeah.
TV, and we showed you exactly what it is we're talking
And
about.
I'm not even going to tell you what I thought when I saw it.
And Judge, this is not a court trial. You're not the finder of fact. We have facts.
I know it, and that's why I let it go to the jury.
We have.
So we're asking.
That's what we're asking, is that the jury be allowed to consider the state's evidence, is essentially what we're asking.
I don't think, Your Honor, you would have allowed Mr. Armstrong to testify yesterday. I don't think you would have allowed him to testify in rebuttal, unless you had made some determination that there was some basis for this.
What I made a determination was that I thought the jury should make the decision.
And that's all we're asking.
So that's your best picture, the one I saw over there?
No.
Where's the best picture, please?
Ooh, the judge is getting a little bit heated.
Finder of
You're
fact.
asking me to give an instruction. I want to see the best picture.
It's the,
We need to get Mr. Stute over here, I think.
we need it on the big TVs.
You need it on the big TV?
The judge is heated.
Are you talking
All
about
right,
82?
bring it up if you would.
What is that?
82 is the slow.
No, I think the best picture is on the original drone or the normal speed one.
73, you say so.
Judge, I think using the defense, we've got the exhibits on our, one of our laptops that I think Mr. Stute has. I've texted him to come on over, but I think Ms. Wisco is graciously going to be able to play them for you. I would recommend watching them on the 4K TV. I think that's the best way to see them. So we can set that up. There is the full drone footage. There is the slowed down drone footage. And then, of course, we have the photographs that Mr. Armstrong had yesterday. So. Yeah. Judge, again, I would recommend, like yesterday, coming and watching on 4K TV.
Which adds pixels if it's not 4K quality.
What's that?
Is it this TV
It's your TV.
adds pixels to something unless it's 4K quality? It does next to me.
It's your
It's
TV.
common sense and judgment, Jim.
There's no evidence.
Oh,
Are you saying I'm lying?
I have no idea.
I'm saying there's no evidence on that.
I'm asking.
But
I'm
you-
saying there's
another,
no evidence.
Well, it's common
Questionable argument.
sense.
You brought in this TV. to show the exhibit.
Yeah,
brought
the
in the
4K
TV.
drone.
You brought in the TV to show the exhibit. So that's what we're doing.
Yeah, I'm gonna take my photos.
Common sense, Jim.
This is the unedited.
Okay.
Is this unedited?
I gotta isolate that.
So Judge, we're going to be focusing your attention right here at the base of this
Right.
sign. Okay, that's where the defendant is going to come into. Go ahead. Okay, you can stop because we're past it now. Now, this is the same quality as our version, is it? Yeah.
Our version is much clearer.
Yeah. We'll have to get our.
I have the enhanced one, I can play as well, but that is exactly what we got from you. I got one that's straight from Dropbox.
Yeah, Mr. Stutz coming
So
up.
what you're showing me now is, this doesn't show anything. This is what was provided to the defense?
Yes.
Mr. Stutz on his way. Here.
I downloaded that straight out of Dropbox, so if your version's clear, that means that you didn't give us your version.
It's just playing weird.
That's not how that works.
Yeah, definitely upscale it. All right, guys. We are brought to you by JSD Supply. JSD Supply makes some really sick PAD kits. Check them out over at JSD Supply. Super chats are always welcome. They're not required, but they are always welcome. Support your creators, whether it's me, Dark, or Rich. Even though I'm the only one on here, but that's fine. I love those guys. They are my boys. That's why I'm broadcasting to their channels as well. Also, I have a Patreon at patreon.com/John Crump. I do a bunch of stuff, and I might need your help a little bit. Yeah, tough days. Remember, never trust anyone, or very few people. Without going into anything, the volume's down on there. My friends have asked me to broadcast on their channels to create content and to get them some money, ad revenue. No, I was just betrayed and stabbed. Tark's like, dude, it will come out eventually, but yeah, right now I was stabbed in the front.
Is this the zoomed in or the regular?
This is the regular version.
So we're looking right here. This is the defendant. He puts it down, he raises it up right there. He has it pointed until Rosenbaum approaches, then he runs around.
Try it again, please.
Play it
Try
again, please.
And can you slow it down?
We have a slow.
Not this version, we have a different version of this.
That's what you watched yesterday.
Go ahead, sir.
Right here is the gun. Right there is the gun right here. Oh, wait, no. It looks very similar to that when he points it here, Mr. Rosenbaum.
One more time.
Here, Stu, let me pause it 1 second in, please.
Start playing.
Pause.
Pause.
Right here. If you watch it, when he goes right up here, he puts the fire extinguisher down gently. It topples over, and he immediately raises up like this. And the gun is right, we argue, right here. And he stays in this position like this until you see Mr. Rosenbaum come around. So Mr. Rosenbaum, if he is yelling gun, 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 we would argue it's to warn all these people that he is pointing a gun at them, and that he is chasing him out of the area to avoid danger. But if you see right here, the state believes, with all the motions taken, that's the gun. And here's it's right here.
Is that where Mr. Rosenbaum yells, "You're not going to do shit, MFer"?
We can talk about this on closings if you want.
I was just curious.
What's that?
I said I was just
All right.
curious.
All right.
So why don't you play it from the beginning one more time? You see him drop it right there as Mr. Rosenbaum approaches. Or lower it, I should say.
It's been a really interesting trial. Usually, trials aren't that
Would you
interesting
like
as
the
this is.
slow down one?
I'd like to see the enhanced one now.
In normal speed or slow speed? Do the zoom in normal speed.
Zoomed in normal speed.
Do you need a number?
Yeah. It's 81 and 82. Yeah, 81 first, then 82.
So this is slightly cropped and normal speed.
But the court reporter wants to use the wireless mic.
Oh, so this is the defendant right here. You can see the AR-15 is on his chest. The fire extinguisher you can't see right now because it's blocked by this man in the wheelchair. But you'll see him walk up again. He will gently place the fire extinguisher on the ground, although it will fall over, and then he will immediately raise his gun up and point it at the individuals who are over here, who I think are right now blocked by this street light. But they're the Zeninskis. Okay, go, Brian. See him lift it right there. He's holding it right there until Mr. Rosenbaum approaches. You see the very distinct motion of him raising his arms, and you see the black gun being raised. One more time, please.
You'd agree he's fake if that's true. He's doing it. open to the camera.
Well,
So
you know what?
No, I would not say that.
it's okay.
So here's the gun. Puts it down and raises it right here. He still has it up right there, and then he drops it and runs. Would you like the slowed down version?
Yeah, please.
Slowed down version, please. So here's the defendant here. There's the AR-15 right there. Play it, please. So he's coming into frame, he drops the fire extinguisher, and he raises it right up. He has it up right there, you see him bring it down, and you see him start to run. He's pointing it at Joshua Zeminski, who probably is vandalizing or committing arson, but that's another.
Where's Zeminski's gun?
We don't believe he has his gun out at that point.
Wait a minute. What?
He fires it.
I didn't hear what the judge
What, I'm sorry?
I said, where's Zeminski's gun? I meant, what I meant to say was, does it depict Mr. Zeminski, or
Shooting?
Mr. Zeminski's gun?
At this point, no, it does show him shoot in the air.
Oh, that's over later, over there.
Yeah.
But I'm talking about at this point.
I don't believe it shows Mr. Zeminski's gun.
Does it show Mr. Zeminski?
Can you play it again, Brian? He's kind of
Or
hidden.
Mrs. Zeminski?
They're kind of hidden by this light post.
That's what everybody is saying. I'm so sorry.
Okay, that's all right.
Is it okay? Do you need me to record this?
Um,
I'm getting judge what you were saying.
Yeah, because it's argument.
Can you,
What I have inquired is, well, boy,
go ahead. No, just go ahead.
okay, what I'm inquiring is whether what I'm looking at now depicts.
Do you want to show them?
Mr. and or Mrs. Zeminski, and if Mr. Zeminski, whether or not it depicts the firearm that he is reported to have fired seconds later.
Where the Zeminskis are?
It's very hard to see them because they're dark against the dark Duramax. So.
We only know they're there because of the FBI video. You can kind of see they're blurry. We did not try to do any enhancements on that.
Yeah. I mean, we know from the FBI video.
I can't hear you. I'm so sorry.
We know from the FBI video, Your Honor, that they're in this proximity alongside the Duramax, but because they're darker clothed and the Duramax is a dark vehicle, and of course other issues with the video, it's not, and there's poles and things, so they're in that vicinity. The FBI video, which we can show you, does give you.
I've seen it.
It might be helpful after seeing this now to see that because it kind of gives you a better So.
If you play it, I think I can play it, please, Brian.
Go ahead, Doug.
Are you sure if you're going to speak to a microphone?
I believe
There's-
they're blocked by the light post, but they are right here.
I think this is one of them here. Moving. It's very hard to tell in this video.
But then they walk down this way, and this is where he pull. We don't accept the defendant's story that he had his gun out because in the video you clearly see Mr. Zeminski pull it out of his pocket, fire in the air, and then put it right back in his pocket. So unless he had the gun out and then put it in his pocket in these few feet, we're not accepting the defendant's story. In fact, we believe this contradicts his story that Mr. Zeminski had his gun already out because you see on the next enhanced video, you see him pull it out of his pocket and fire it in the air quick and then put it down.
He keeps it down on his side, and he's walking right down the sidewalk yelling, that dude just shot somebody. You can see the gun clearly in his hand.
No.
Well,
Not in this video.
this sounds like a great argument. Did you want to make any observations about this before I make a decision?
Well, you're gonna see what, I'm cheating here. You're gonna see what you believe that you see, okay? So that question is, does that video provide enough information to give an instruction on provocation?
And Your Honor, how does, if you take everything they've said, that's true, how does pointing a gun at Zeminski provoke Rosenbaum, who they say they don't know each other?
There's no evidence of that. They called it Mr. Rosenbaum is dead, and it's defense of others.
Well-
and it's pointing a loaded firearm, which is a misdemeanor without any real basis.
Well, the evidence, okay, the evidence in the record of the two people is that Mr. Rosenbaum had twice before threatened to kill the accused. So what is the legal effect of a person who, if he made such a threat, what legal justification does he have to chase after the accused? In such a way as to not put the defendant into a position of being a provocateur.
We are absolutely
That's
not.
not well phrased,
We are not accepting the evidence that that threat was made because there are different accounts of where and when it was made, and it's like the only 5 seconds not caught on video all night. So, but like you said, Judge, it'll be a great argument, and I do not believe that Mr. Rosenbaum does not give up the ability to be provoked because he may have said things an hour earlier. If this individual, now remember, there is evidence in the record that he was accused of pointing guns at other individuals for property crimes. The defendant admitted he responded sarcastically to one of them. On the video, he sort of sheepishly and quickly walks away after admitting he pointed a gun at someone for property crimes. The state's belief is that he pointed a gun at Mr. Zeminski for another property crime, and this dangerous behavior, pointing this loaded, powerful weapon at someone for, at the most, perhaps stoking a fire that's already been lit, would be provocation. Committing this unlawful act would be provocation for anyone to intervene and try to chase him away, whether or not threats have been made. And I know Your Honor takes these threats seriously, but we've also seen thousands and thousands of threats to kill that have never been acted upon. This guy, Mr. Rosenbaum, was described as a babbling idiot. There's no evidence he ever caused any physical harm to anyone that night. And frankly, even if he had threatened, he had no means to carry out his threat. So, as you said, it's a great argument. There's evidence in the record, not just by video, also by testimony, and there's enough evidence to give this instruction. If the jury does not accept this argument, if we do not meet our burden, that probably is beneficial to the defense, but it should at least be argued as the evidence does support it. And it goes directly in contrast to what the defendant testified to.
Do you want to respond?
Judge, it's been hashed over.
Well, it's the jury's, it's the jury's case, and I think they should make the critical decisions. My decision will be to submit the case to the jury with the provocation instruction, and you can argue the strength or lack of strength of the respective evidence. So I will give that instruction, and I'll give you didn't dispute the retreat, did you?
I don't think I did. I don't think if you look at the comments, it's not necessary. It says right in the comments, the committee concluded that while reference to duty to retreat is arguably unnecessary, given the potential relevance of retreat to the reasonable use of force, it's advisable to continue to publish it. It is intended to be optional in the sense that it is to be used only when the trial judge concludes that retreat is an important issue in the case, and the jury's understanding will be aided by a statement of rather than the general legal standard that applies. So I don't think that under these circumstances there's any, can't say it's unfavored, but if you look at the comments, there's no reason, in my opinion, to give it. He does retreat. There's no argument about that, but I don't think it's necessary to be given.
Judge, I believe that it is appropriate in large part because this was, that there is no duty to retreat was mentioned in opening, and I believe Attorney Tarofsky referenced it in a cross-examination that the defendant had no duty to retreat. So I believe that there should be, that's been put out to the jury, there should be a fuller explanation of what that means, that they can decide and they can see if there was opportunity to retreat. We see the defendant has plenty of open space in which to retreat. He does so right after shooting Mr. Rosenbaum. And also,
Well, yeah, no, I'll say that. Everybody was scattering then, and that dramatically changes the situation.
if you look at the FBI video where he ran to, there was absolutely no one there before the shooting.
The FBI video does not pick everybody up. The Zanin video shows it clear as day. There's 100 people over there bashing on windows.
Yeah, the Zanin, I don't remember which it was, I think it was Zanin.
Zanin.
Video, to me depicted a large number of people who were engaging in violent activity, well, property violence, but it's still, they're using clubs and wrenches or whatever else to be doing destruction to those cars that are right in the area which would have been the path of flight for the accused, and I'm wrong about that?
Yes.
In the Zanin video, you hear the 5 gunshots. You hear the first gunshot, which is Mr. Zeminski, and there's kind of a flinch of the crowd, and then you hear the 4 shots that Kyle fired.
Yeah, let's have a look at it. I sure formed the impression when I looked at it that this is just to the south of the area where the shooting took place, and that there was a very large group of people in there who were intent on riotous activity.
I agree that the southern portion of the walkthroughs, the defendant testified that his first instinct was to try and head north on Sheridan, that he could not because Mr. Rosenbaum was there. But as their testimony is that he was somehow trapped or blocked in these rather loosely parked cars. And you will see, I believe in the video, that the route the defendant takes after shooting Mr. Rosenbaum.
I don't want to hear about after, because after, that's a different situation entirely.
All right, well,
Watch the video. Let's watch the
Okay.
video. Sure, you can put the sound on if it's there.
So over here, across the hospital.
Can you pause it, please? Or go back 2 seconds? The defendant runs here. There's no one in that area.
I will mind
Wait for the gunshots. Which comes in a minute and 10 seconds approximately.
It seems to me that there's quite a bit of flight from that otherwise congested area after the shots are fired. So prior to the shots being fired, there were quite a crowd there.
Judge, I don't believe there's a crowd where the defendant ended up retreating to, but
Ended up is after the shooting had occurred.
I understand. So my main reason for wanting this instruction, or our main reason, is that the defense has already stated that there is no duty to retreat. So they've already put that in evidence. I imagine they will argue it again in closings. So I believe the jury should properly be able to instruct on the law regarding retreat.
Did you want to respond?
Your Honor, he's arguing the instructions, I'll keep my mouth shut. I said, he's arguing the instructions, I'll keep my mouth shut.
You saw the video, Judge? There's hundreds of people with weapons causing damage. What happens after doesn't matter because it happens after. And I'm trying to do this on the law, which is that it's unnecessary based on the fact that self-defense is going to be given. And the question was the use of force in the situation reasonable? That is contemplated by not giving 810. That's what the committee says.
My inclination is to give it, but if I find it's adequately covered in the other instructions, then I won't.
Okay.
All right, anything else?
Judge, I don't know if there's any jury instructions. Obviously, this case, anyone can pull up any video testimony of anyone testifying. I'm just wondering if the court feels it appropriate or allowable to play portions of testimony to the jury on closings.
You mean from media sources?
Yes.
Wants to play court TV.
Well, I'm not saying we want to. I'm saying we should talk about it now before anyone tries.
Well, that's a good point. I don't want to specify one, Court TV has certainly, and I might add, has done a magnificent job in this trial, in staying out of my way and just keeping things going, I think. So I'm not saying you shouldn't follow that. You could use any source that is carrying it, except not one where they're commenting on it one way or another. Of course, no one would do that, at least not if he knew what was good for him. So unless there's some objection, I don't have any problem with that.
I don't think it's appropriate.
We're not seeking to do it. I just wanted it out there before someone tried to do it.
I'm happy to agree that we're not gonna do it.
Oh, okay, well, let's do that
I just
then.
didn't want to be blindsided.
Let's
so.
do that. Okay, so there won't be anybody doing that. Now, but you bring up a good point. If the jury goes into deliberation and wants to look at some of this evidence, of course, one would read the law, I think, nowadays to say that any scrutiny by the jury should be in the presence of the court here in the courtroom. I very, very strongly disagree with that. I think that's antiquated. I think that that's based actually on a case I tried right here. Once again, I was there. State against Maurice Pucci Franklin. And I'm not going to go into my usual dissertation on that, but that led to, I think, the Anderson case about showing videos and things. The law actually developed around recorded statements of the accused as opposed to videos of the actual events. But I think the general rule now is supposed to be that we're supposed to do all this under judicial scrutiny, and they have to ask permission, and then we have to supervise. One of the things that I find most offensive is that we've got to scrutinize it to make sure they don't play it too many times, so they don't overemphasize some aspect of the evidence. I think that's what the cases say. And I think, how dare us, the founders of the Constitution, have juries because they don't trust the judges, and the judges have spent the last 225 years returning the compliment by always suspecting that the jurors are going to be up to no good. If this were a bench trial and like this, I watched it. How many times have I watched that video now? And you know what? I could sit and I could watch it maybe 50 more times. And in fact, the famous Boston Marathon bomber was resolved because an agent from the FBI watched the video over and over and over and over again and finally realized what nobody else had caught, which was that Mr. Zanayev, who is now under death sentence, well, temporarily not. We don't know what the outcome will be in the Supreme Court, but that everybody else was looking one way and he was looking the other. And it took numerous times looking at the video to solve that crime. So for me to monitor how many times the jury looks at something, if we're a bench trial and I looked at it 100 times and I finally decided I better not look at it anymore because I might prejudice myself, I'd get reversed because that's an absurd thing to say. So I don't want to sit here and monitor how many times they look at something. I did that once when when it was an attempted murder case of a police officer, and the jurors came down and they're told they can't even discuss it with one another, but they can't resist, and so they're saying, oh, look at that, and then I send them upstairs and they're not looking at it again, and I think that's really frightening. So I think if they want to see the exhibits, we should give them the equipment to see it and let them do what they want with it. So that's what I think. Now let me hear from you.
Judge, I agree with you that is antiquated. I think this is the ideal case where giving them access or setting them up somehow with the exhibits would be great. I saw this as a issue. I did ask people at the Department of Justice to look into it. Not a formal opinion. They indicated they believe it would be reversible error. I asked even if there was a stipulation and if the defendant agreed, and they thought it would still be reversible error under the current law, and also, and I'm not saying it would be ineffective, but they thought it would raise an ineffective assistance of counsel claim if there is a conviction. I do not want this case to be a test case on long-established law. I agree that the law is antiquated, and with the explosion of technology in the last couple decades, it needs to be changed, and perhaps we can do so legislatively, but as it stands now, the state feels that we should follow the procedures, as antiquated they may be.
Defense?
I don't want them having a free-for-all up in the deliberation room.
Okay. Well, I'm not going to cram it down on this case. One day, with a short trial,
One that you're willing to do twice.
yeah, this is crazy. It's just absurd. And I'm the one, I guess, who was the dinosaur on technology, but I certainly respect it more than our law does. We need to talk about the lesser included offense instructions, Mr. Rittenhouse. The effect of these, right now, the charges against you, which are stated in the amended information, counts 1 through 6, the district attorney has to prove each of them beyond a reasonable doubt in order to obtain a conviction on that particular count. And there's something called lesser included offenses, and I'm sure your lawyers have discussed it with you, but I want to make sure that you understand it, and I'm required to do that. And if the district attorney is not able to establish your guilt on the charged offense beyond a reasonable doubt, then the jury is instructed that they must acquit you, find you not guilty. If a lesser included offense is presented to the jury, any of the ones we talked about, which are less serious crimes, carrying a lesser potential sentences, if I allow those, then the jury, if they are unable to agree that you're guilty of the charged offense, will have the opportunity to consider whether you're guilty of the less serious offense, and could return that as a verdict, as an alternative to instead returning a verdict of not guilty. So you were, by having a lesser included offense included, you're raising the risk of conviction, although you are avoiding
Thank
the
you, Ro, for
possibility
the
that
super
the jury
chat. One thing I noticed, Kyle
end up compromising on
Kyle did a
more
lot better
serious crime.
shooting than most police. I wonder
And
who
you're also,
trained him. I want to
increasing
shake
the,
their hand.
de-
That's one thing I
decreasing the
did
risk that
notice.
you'll end up
He
with a
seemed to
second
know what he
trial
was
because
doing.
the jury is unable to agree. Any question about any of this so far?
No, Your Honor.
Okay, if the jury finds that none of the crimes charged in the sequence, charged or submitted, has been proved beyond a reasonable doubt, then they must acquit you, they must find you not guilty. And they cannot convict you of more than one crime on each count. Okay?
Yes, Your Honor.
Your lawyers have objected to some of the lesser included offenses and not others. They have, on some of them, they have agreed that they're appropriate. You don't have to join in that agreement if you don't want to, and you have the legal right to overrule them. And we'd have to talk more about it if you decided to do that, but you would have that legal right and say, no, I want to go to trial on just the charge offenses, all or nothing, and make the decision to force the district attorney to prove each case beyond a reasonable doubt. That would be your decision. Have you had enough time to talk with your lawyers about this?
I have.
Have you had enough time to think about what you're doing?
Yes, I have.
Do you think what you're doing is the best thing under all the circumstances?
Yes.
Has anybody threatened you or pressured you or forced you in any way?
No.
Has anybody promised you anything in exchange for this?
No, they haven't.
Is your mind clear today?
Yes.
Are you feeling all right?
Yes.
Have you ever been treated for a mental or emotional disorder? Well, let me ask you this. The more important question is there any reason for me to be concerned that you have some kind of a disability, mental or emotional, that would prevent you from being fully aware of what your options are and making a rational decision? Any reason I should be concerned about that?
No, Your Honor.
Okay. Any other question anybody wants asked on this?
His pause was, I believe, because he's in therapy. I don't think he has a mental illness or anything.
Okay.
As a result of this incident,
Okay.
he has PTSD.
Okay. And but that doesn't affect his judgment or reasoning power at all?
So,
No.
He's wagging his head, no, okay. Anything else before I accept his decision on this?
No.
All right, so I'll accept the waiver and instruct accordingly along the lines that I've already indicated. Anything else today?
Judge, while you were doing the colloquy, I looked at my email. I got another screenshot of someone saying they know someone of the jury. I forwarded it along, just for transparency reasons, to the defense and to the court. Only one now.
disappointed.
I didn't get it yet.
That is the link.
yeah,
It's
here it
one
is.
link that goes to L. So we're all streaming. So yeah, you can jump on. But I think they're almost done. So by the time you get back from the dogs walking, it might be over. Band talk. That's the whole point that I've been trying to make. Band talk says the whole trial exists to subvert our right to self-defense.
all right, thank
which
you.
it does. All right, and that is it, guys. We will see what happens in this trial. We'll be back Monday. Monday probably will be closing arguments. Probably about 5 hours of closing arguments with everything. But that is it. Let's see if there's anything else said. Nope. that is it. We will see you guys Monday. Thank you so much for watching. Thank you for all the support. I know I'm not in a good place right now, but shit happens. Where I go from here, I don't know. Haven't made up my mind, but we'll see. Sure, more will come out, but right now, that's all I'm saying. All right, guys. I love you guys. And I guess I will see you Monday.